We all know that this act, known as Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, came in 2013. Earlier to that, the field was occupied by Vishakha case, where Supreme Court had given directions to deal with this problem. Now, a division bench of Supreme Court consisting of A.S. Bopanna and Hema Kohli on 12th of May 2013 in case of Aureliano Fernandes versus State of Goa, which was reported as AIR 2023 Supreme Court 2485, have given a very landmark judgment expressing displeasure on the implementation of this act. I would like to read some paragraphs from the judgment and would suggest that everyone should go through this detailed judgment to understand the importance of this law and how it is badly implemented. And it is required to be implemented with all seriousness in order to protect women at workplace. In para 74, the Supreme Court had said, just as we celebrate a decade of Prevention of Sexual Harassment Act being legislated, it is time to look back and take stock of the manner in which the mandate of the Act has been given effect to. The working of the Act is centered on the constitution of the Internal Complaints Committee, that is called ICCCs, by every employer at the workplace, and constitution of local committees, that is called LCs, and the internal committees, that is called ICs, by the appropriate government as contemplated in chapters 2 and 3 respectively of this Act. An improperly constituted ICC, LC and IC would be an impediment in conducting an inquiry into a complaint of sexual harassment at workplace as envisaged under the statute and the rules. It will be equally counterproductive to have an ill-prepared committee conduct a half-baked inquiry that can lead to serious consequences, namely imposition of major penalties on the delinquent employee to the point of termination of service. The Supreme Court saying further, it is disquieting to note that there are serious lapses in the enforcement of the Act even after such a long passage of time. This glaring lacuna has been recently brought to the fore by a national daily newspaper that has conducted and published a survey of 30 national sports federations in the country and reported that 16 out of them have not constituted an ICC till date. Where the ICC have been found to be in place, they do not have the stipulated number of members or lack of mandatory external member. This is indeed a sorry state of affairs and reflects poorly on all the state functionaries, public authorities, private undertakings, organizations, and institutions that are duty bound to implement this Act in letter and spirit. Being a victim of such a deplorable act not only dents the self-esteem of a woman, it also takes a toll on her emotional, mental, physical health. It is often seen that when women face sexual harassment at workplace, they are reluctant to report such misconduct. Many of them even drop out from their job. One of the reasons for this reluctance is to report is that there is an uncertainty about who to approach under the Act for the redressal of their grievance. Another is the lack of confidence in the process and its outcome. This social malady needs urgent amelioration through robust and efficient implementation of the Act. To achieve this, it is imperative to educate the complainant victim about the import and working of the Act. They must be made aware of how a complaint can be registered, the procedure that would be adopted to process the complaint, the objective manner in which ICC, LC, IC is expected to function under the statute, the nature of consequences that the delinquent employee can be visited with if the complaint is found to be true, the result of lodging a false or a malicious complaint, and the remedies that may be available to complainant if dissatisfied with the report of ICC, LC or IC, etc. However salutary this enactment may be, it will never succeed in providing dignity and respect to the woman deserves at workplace unless and until there is strict adherence to the enforcement regime and proactive approach by all the states and non-state actors. If the working environment continues to remain hostile, insensitive and unresponsive to the needs of the women employees, then the Act will remain an empty formality. If the authorities, management, employers cannot assure them a safe and secure workplace, they will fear stepping out of their homes to make a dignified living and exploit their talent and skills to the hilt. It is therefore time for the union government and the state government to take affirmative action and make sure that ulterior object behind enacting this act is achieved in real terms. Supreme Court has given certain directions. These are to fulfill the promise of this act holds out to working women all over the country. It is deemed appropriate to issue the following directions. Number 1, the Union of India, all state governments and union territories are directed to undertake a time-bound exercise to verify as to whether all the concerned ministries, departments, government organizations, authorities, public sector undertakings, institutions, bodies, etc. have constituted internal committees, local committees, as the case may be, and that the composition of the said committee are strictly in terms of the provisions of this Act. Number 2, it shall be ensured that necessary information regarding the constitution and composition of these committees, details of emails, ID and contact numbers of the designated persons, the procedure prescribed for submitting an online complaint, as also the relevant rules, regulations and internal policies are made readily available on the website of the concerned authorities, functionary, organization, institution, body, as the case may be. The information furnished shall also be updated from time to time. 3. A similar exercise shall be undertaken by all the statutory bodies of professionals at the apex level and state level, including those regulating doctors, lawyers, architects, chartered accountants, cost accountants, engineers, bankers and other professionals, by universities, colleges, training centers and educational institutions, by the government and private hospitals, nursing homes. 4. Immediately and effective steps shall be taken by the authorities, management, employers to familiarize members of the ICC, LC, ICs with their duties and manner in which an inquiry ought to be conducted on receiving a complaint of sexual harassment at workplace. from the point when the complaint is received till the inquiry is finally concluded and the report submitted. 5. The authorities, management, employers shall regularly conduct orientation programs, workshops, seminars, and awareness programs to upskill members of ICC, LC, ICs, and to educate women employees and women's group about the provisions of this Act, rules, and relevant regulations. 6. National Legal Services Authority, that is called NALSA, and the State Legal Services Authority shall develop models to conduct workshops and organize awareness programs to sensitize authorities, management, employers, employees, and adolescent groups with the provisions of the Act, which shall be included in their annual calendar. 7. The National Judicial Academy and the State Judicial Academics shall include in their annual calendars orientation programs, seminars, and workshops for capacity building of the members of ICCs, LCs, ICs established in High Court and the district courts, and for drafting standard operating procedure, that is called SOPs, to conduct an inquiry under the Act and rules. 8. A copy of this judgment shall be transmitted to the secretaries of all the ministries, Government of India, who shall ensure implementation of the directions by all the concerned departments, statutory authorities, institutions, organizations, etc., under the control of the respective ministries. A copy of the judgment shall also be transmitted to the chief secretaries of all the states and union territories, who shall ensure strict compliance of these directions by the concerned departments. It shall be the responsibility of the secretaries of the ministries, Government of India, and the chief secretaries of every state, union territory to ensure implementation of the directions issued. 9. The Registry of the Supreme Court of India shall transmit a copy of the judgment to the Director, National Judicial Academy, Member, Secretary, NALSA, Chairperson, Bar Council of India, and the Registrar General of all the High Courts. The Registry shall also transmit a copy of the judgment to the Medical Council of India, Council of Architecture, Institute of Chartered Accountants, Institute of Company Secretaries, and the Engineering Council of India for implementing the directions issued. 10. Member Secretary NALSA is requested to transmit a copy of this judgment to a Member Secretary of all state legal services authorities. Similarly, the Registrar General of the State High Courts shall transmit a copy of the judgment to the directors of the State Judicial Academies and principal district judges of their respective states. 11. The chairperson, Bar Council of India, and the apex bodies mentioned in subpara 9 above shall in turn transmit a copy of the judgment to all the state bar councils and the state level councils, as the case may be. These are the directions by the Supreme Court, and I think and I hope that the women organizations, women right activists, and the authorities should go into this judgment and see that this act, I am coming again to this, sexual harassment of women at Workplace Prevention, Prohibition and Redressal Act 2013 is effectively implemented. Thank you.